Welcome to Dictation vs Steno.
3, 2, 1.
Start. Reservation in public employment was given because the farmers wanted the backward classes to share state power, and for that matter, they had to be provided equal opportunity. Stop. The Assembly intended to extend the benefits of affirmative action to only those socially and educationally backward groups who had been excluded from mainstream national life due to historic injustice, stigma, and discrimination, and thus, bringing in any other criteria, excluding the communities who have suffered such stigmatization, would be a blatant violation of not only the equality code but also the very principles of democracy, both of which form part of the basic structure of the constitution. Stop. The Learned Council would submit that the criteria for backwardness was always social in nature and economic backwardness was never accepted as the sole criteria. Stop. Placing reliance on the decision of this court in Indra Saurne case, he has contended that by the majority of 8/1, it was held that economic criteria cannot be the sole basis to grant reservation under Article 16. Stop. Drawing attention to the theory of substantive equality propounded by Professor Sandra Friedman, the Learned Council has submitted that reservation solely on economic criteria would violate the principles of substantive equality ingrained in the Constitution, which was directed against identity based historic marginalization. Stop. Next. Learned Council has further placed reliance on Indra Sauhani case to draw distinction between backward class and weaker section discussed under Articles 16 within bracket 4 and 46, respectively. Stop. It has been argued that the latter has no limitations and thus, Article 46 cannot be the basis for providing reservation. Stop. He has also urged that exceeding 50%, limit would violated the twins tests of width and identity, as propounded by this court in and result in disturbance of equality, and that 50%, limit cannot be breached under any circumstances except if a law is protected under the ninth schedule to the Constitution, which the amendment in question is not. Stop. He supported his argument citing Indra Sauhani case, wherein it was held that reservation under Article 16 within bracket 4 should not exceed 50%. Stop. Traversing through the history of reservation policy since the year 1872 and the decision of this court in state of Madrasa versus Champakam, Professor R. Kumar, learned senior counsel, has submitted that the ratio of decision of this court in Champakam, that classification on the basis of religion, race, caste, language are the ethos of constitution as such. Stop.